prior LaborSpeak videos, we have discussed the aggressive stance that the Delaware Court of Chancery has recently taken against non-competes. One of the cases we discussed was Ainsley v. Cantor Fitzgerald LP, where the court found as unreasonable and therefore unenforceable a limited partnership agreement's forfeiture for competition provisions that conditioned payments from partners' capital accounts and other payments on partners not breaching non-compete and non-solicit restrictions for 4 years. But last month, the Delaware Supreme Court reversed that decision. The court focused on what it referred to as a significant difference between non-competes and forfeiture for competition provisions, noting that non-competes explicitly prohibit individuals from competing, whereas forfeiture provisions only condition certain payments on individuals not competing. Forfeiture provisions, the court held, do not deprive individuals of their livelihood or expose them to risk of financial hardship like non-competes do. Therefore, forfeiture provisions, unlike non-competes, can be treated just like any other bargained for term. A large portion of the decision, including the very first sentence, focused on Delaware's long-standing policy and case law honoring freedom of contract. This could be taken as potential guidance for the Court of Chancery to tone down its recent stance on restrictive covenants. However, the decision concentrated on the individual status as partners rather than employees. Further, the Delaware Supreme Court has not ruled on the Court of Chancery's recent decisions in which it refused to enforce or modify certain non-competes in other situations, including a non-compete that prohibited competition against affiliates alleged to be unrelated to the relevant business, and a non-compete that was global in scope despite the relevant company only doing business nationally. So while it remains unclear whether a Delaware court will apply this latest holding to all non-competes or similar forfeiture provisions governing employees, employers now have good support for the use of forfeiture provisions against partners if the relevant documents are governed by Delaware law. Still, employers would be wise to think carefully when designing their agreements about what protections are needed for the business and consider which applicable governing law might be most favorable to achieving those protections. If you have questions about this case or any other issues relating to restrictive covenants, feel free to contact our team.